So we thought that this was a good opportunity to revisit the negotiations of the convention. And that's what we intend to do through these series of webinars across the year. And then eventually we'll move to a major workshop or conference to be held to celebrate the 40th anniversary on the 10th of December. So the general theme that we have for the year is looking back to the future in the law of the sea, UNCLOS III and the LOSC at 40. And our opening webinar today is on Australian and New Zealand perspectives on the negotiations of UNCLOS III. And hopefully you've seen some of the details with respect to our second webinar, which we'll be holding on the 26th of April, which looks at the same issue, but from a Pacific perspective. And we're in the process of confirming a number of speakers from across the Pacific to look at the UNCLOS III negotiations and the significance associated with the conclusion of the convention. So further details of that program will become available across the year, and those of you who are interested in this topic, please look out for those as we finalise those developments. I'll now hand over to my co-chair for this particular event, who will be the host for this evening and the chair for the moderated discussion. I welcome Dr. Camille Goodman. Camille is a senior lecturer at the Australian National Centre for Ocean Resources and Security, ANCORS, at the University of Wollongong. And I'm absolutely delighted to say that Camille recently completed her PhD under my guidance at the ANU a few years ago. So Camille, thanks so much for joining me in this venture, and over to you.
Thanks, Don. It's an absolute privilege to be part of this series, and I'm really pleased to chair this evening's webinar on Australian and New Zealand perspectives on UNCLOS III and the Law of the Sea Convention. Tonight, these perspectives are going to be provided by four fantastic speakers on our panel. From Australia, we have Mr. Henry Burmester and Mr. Richard Rowe, and from New Zealand, Mr. Bill Mansfield and Dr. Penny Ridings. All four of our speakers are former senior legal advisors to their respective governments, and they all have enormous experience and expertise in the law of the sea. They've all made significant contributions to the law of the sea in Australia, in New Zealand and beyond over the course of long and illustrious careers, which you can read more about on the website for this webinar. And there's a link to that in the chat. With my ANZL hat on, I also want to acknowledge the important part that these people have played in the international law community in Australia and New Zealand over the course of their careers, including through engagement with the activities of ANZL and by sharing their knowledge and experience to assist the development of many more junior members of the profession, and I count myself in that number. Tonight, we're all going to benefit from that knowledge and experience as they share their unique perspectives, professional, practical, perhaps even personal, on the negotiations at UNCLOS III and on the implementation and operation of the Law of the Sea Convention. So let's start at the start with the negotiations at UNCLOS III. And I'd like to start with Bill. Bill, you attended all the sessions of UNCLOS III as a member of the New Zealand delegation. I wonder if you could talk a bit about New Zealand's key objectives for UNCLOS III and perhaps strategies for achieving them, and any key roles or groups or alignments that New Zealand found itself in.
Well, thanks, Camille. Let me start by noting perhaps an obvious point that New Zealand is an ocean-locked country. We're surrounded not by other countries, but by enormous oceans. Our trade's dependent on our ability and our trading partners' ability to ship goods across them. Our tourism industry is dependent on commercial aircraft being able to fly across them. And in resource terms, we assert the right to one of the largest EEZs in the world, and also to a broad continental shelf that goes beyond it in many places. Now, the public tends to take the situation for granted and seems to assume it's the natural order of things and will continue indefinitely into the future. Certainly, there's little public recognition that the situation we currently enjoy is founded on an international treaty, UNCLOS, that following the collapse of the old order took 3 UN conferences, the third of which lasted more than a decade, to develop. There's even less understanding, I think, of A, the tensions and potential conflict that impelled its negotiation, B, the delicate balances and compromises that were necessary to reach agreement, or C, the serious implications for New Zealand if new issues are not managed carefully and lead to its unravelling. Now, the importance of the convention as a constitution for the oceans was widely recognised at the time of its adoption. But looking back, it's important to remember that the balancing of interests that enabled the adoption of the convention was extremely complex. It's highly unlikely, in my view, it could ever be reconstructed, or that any attempted renegotiation would produce a result as favourable for us or as effective in securing international peace and security. As we approach the UNCLOS III negotiations, our objectives were protecting our trading routes, obviously, long-term management of the living and non-living resources in the seas around us, including marine pollution, and clarity and certainty about the law of the sea, and especially the extent of coastal state jurisdiction, and all backed, we hoped, by a compulsory third-party dispute settlement system. This actually involved a significant shift of position for us. In the first and second attempts by the UN to settle the law in 1958 and 1960, we supported the maritime powers in their efforts to preserve traditional high seas freedoms and resist coastal state claims to expanded jurisdiction. But before UNCLOS III began, there was a major rethink of our position involving what was then, I think, the longest cabinet paper anyone could remember. And the government accepted that on the fundamental issue of the extent of national jurisdiction, our interests lay not with the maritime powers, but with other coastal states. And this shift in position was based on the emerging concept of the EEZ. And early in the first session in Caracas, in 1974, we joined Canada, Chile, Iceland, India, Mauritius, Mexico, and Norway in tabling a fairly intellectual paper outlining this concept. And at that time, of course, this new concept was still opposed by the major maritime powers. The rights and obligations within the EEZ took the best part of the next 10 years to negotiate and settle. We played our part in that work, but the major focus for our delegation was the battle over whether small islands could be entitled to EEZ on the same basis as other land territory. This was a critical issue for New Zealand and the Pacific Island countries. Much of our time was spent on it, and we formed the Oceania group to plan our strategy, tactics, and lobbying efforts. Now, there isn't time to talk about it in any detail, but suffice to say that at the outset of Caracas, it was clear more than half the conference was opposed to our fundamental position that islands should have the same maritime spaces as any other land territory, and also that many of the major players on the islands issue had barely focused on the existence of, let alone the problems of, mid-ocean island nations. You know, their remoteness, limited land area, and dependence on the surrounding ocean for food and for any prospect of future development. In the end, the result was a good one for the Pacific Island countries and Australia and New Zealand. On the issue of islands, it showed that the small delegations of Oceania could be very effective, something they've demonstrated again in the climate change negotiations. And more generally, small countries are dependent upon a rules-based rather than power-based international system. And in relation to the oceans, UNCLOS remains the cornerstone of that system. In this regard, and since we're reflecting on the 40th anniversary of UNCLOS, I'd like to end by paying tribute to the leaders of the negotiations through the 1970s and early 80s, time and again, when the negotiations were at a standstill and collapse seemed inevitable, they found a way forward. And in doing so and taking a leap in the dark, they recognised that for the sake of the wider international community, national positions had to be restrained sufficiently to allow the negotiations to move forward. And I think the parallel with the situation that has faced and continues to face climate change negotiators is striking. Thank you.
Thanks, Bill. I think you've got us off to a cracking start there with lots of issues I already have plenty of questions about, and I'm sure other participants might be thinking about too. But I think I should come back across the ditch as such to Henry. Henry, you were a member of Australia's delegation at, I think, the 8th and 9th sessions of the conference in 1979 and 1980. So could you perhaps do something similar in terms of reflecting on Australia's objectives at UNCLOS III and strategies?
Thanks, Camille. I think Australia's interests and objectives are very similar to those of New Zealand, and we work closely together on most issues, I think. We're both island states, and it might be one big one with a few other pertinent islands, but essentially we're an island state with similar problems. The one thing I'd say where I think I differ a bit from Bill, he said we sort of rewrote our interests and our objectives from what they would have been back in the 1958 and 1960 negotiations. But in a sense, I think Australia's interests remained relatively similar. We may not have been as quite deferential to the major powers, but we still wanted our communication routes, our navigation rights, our trading interests protected. But we recognised that resource interests were also important, and hence we were supportive of things like a 200 nautical mile resources zone. And of course, just as we did in the 1950s, we were very strong supporters of extended continental shelf. And to sum up our position, it was essentially, as similar to New Zealand, to get a stable legal regime, a comprehensive and widely adopted convention, and that objective really received bipartisan support in Australia. More specifically, we wanted to have wider resource jurisdiction for coastal states. We wanted our sovereign rights over the continental shelf expressed in clear terms. We wanted agreed rules governing the marine environment. We were prepared to accept the concept of archipelagic waters as long as the rights of navigation were adequately protected, and we embraced the settling of the breadth of the territorial sea as long as there was a clear and agreed formulation of rules relating to innocent passage through the territorial sea archipelagos and straits, and we wanted agreed rules on marine scientific research. But ultimately, our interests were much the same as they've always been since UNCLOS I, in my view. As with New Zealand, we worked in a lot of smaller negotiating groups, and one that stands out is the Margineers group, about 12 states that were particularly keen to see a wide continental margin and rights over that accepted. We were also part of the Coastal States group, but we were not one of the leaders of that pack, as it were. Our coastal state claims were relatively modest, and we recognised that there had to be a balance struck between the rights of freedom of navigation and the rights of coastal states. And we were also part of the Oceania group that Bill has already mentioned. What strikes me about the negotiations was that they were long and tedious. I only went to 4 sessions in 2 years, but I was working on Law of the Sea for a much longer period of time. And back in Canberra, I was struck by the immense level of resources devoted to Law of the Sea issues. There was a task force chaired by Foreign Affairs that met regularly in the lead up to every new session. There were working groups on relevant sections of the Law of the Sea that prepared comprehensive briefs for every session. There were reports written after every negotiation session as to what had happened. There was involvement from a broad range of departments and agencies. It was not just Foreign Affairs and Attorney General's Department. Foreign Affairs provided leadership and some key diplomatic negotiating skills, and obviously were in charge of the overall negotiations. But the delegation was a quite large delegation with people from Attorney Generals, Defence, the Resources Departments, Fisheries, Shipping, Environment, and we also had representatives from the states, usually the State Solicitors General taking it in turn to go, in recognition that many of the maritime issues, particularly those involving the waters close to the coast, involved the interests of the Australian states. One area we particularly worked with New Zealand on was fisheries, both in relation to highly migratory species and provisions about optimum catch and access to fish by foreign fishermen to the exclusive economic zone. As I mentioned, we worked particularly on the continental shelf definition and the issues about how to define it, and that took lengthy negotiations over many sessions. Australia never really reconciled the idea of revenue sharing in relation to the continental shelf, but we didn't let that stand in the way of us accepting the convention when it came to the final crunch. My experience, I suppose, with Law of the Sea, as I said, showed me that the key ingredients to a successful outcome were resources, adequate resources being devoted to it, getting broad consensus within one's own delegation, and so that one worked harmoniously together. And then, as Bill has mentioned, having excellent leaders in the conference overall, but in lots of national delegations. My experience was that it was a fairly convivial negotiation, despite some of the difficulties. Everyone was trying to get a successful outcome, and there were lots of frustrations. The fact that the deep seabed negotiations were, as it were, holding everything else up did cause difficulties. But, and as Bill says, I'm sure a similar negotiation would not likely to be successful today. It's just, I think the world has got far much more complex than it was then. So I'll stop there.
Thanks, Henry. That's a wonderful overview. I know you said it was tedious, but to be honest, it sounds a bit like a golden age for Law of the Sea nerds. Richard, you were also a member of Australia's delegation at UNCLOS III, and I'm particularly envious that you attended the 11th session in 1982, at which the convention was adopted, which we'll be commemorating on the 10th of December this year. Could you talk a little bit about that experience and perhaps about the dynamics of that final session?
Yes, well, thank you very much, Camille, and it's a great pleasure to share this panel with Henry and Penny and Bill, who I've worked with closely over many years. And of course, Australia and New Zealand has already been mentioned, closely collaborated and worked together on Law of the Sea issues, particularly in the UNCLOS context, and being through membership of various groups, which has already been mentioned. But while I'd been working on Law of the Sea issues for a short time in the Department of Foreign Affairs, as it then was, I only ever attended one session of UNCLOS III, and that was the 11th session. But I still have pretty vivid memories of aspects of that session. Some, of course, have faded in 40 years since, but I certainly also took away from that session, in a personal, if I could put it this way, personal development sense, a lot of lessons about how a conference as complex and multifaceted as UNCLOS III was, should be organised and run, and also the skills at you might say, the personal level that should be brought to bear in any negotiations. So I might just mention a couple of reflections on both those aspects. Of course, as we know, UNCLOS III 11th session was dominated by the diplomatic effort to try and ensure that the United States actually supported the convention, which of course was due to be put for adoption at the end of that session. You all know of course, the history behind the United States change of position after President Reagan was elected at the end of 1980. And the United States, of course, conducted a complete review of the convention and its policy approach, and that took all the most part of 1981, and it wasn't until the end of that year that, when the review was completed, that some indications started to appear about the sort of approach the United States might take at the 11th session. And of course, they came out with 6 objectives, which were pretty general in their formulation. And I remember from the Australian perspective, the head of our delegation, Ambassador Keith Brennan, who was a really very strong force in the negotiations, highly regarded and respected, and very skilled diplomat and negotiator. Of course, he was very concerned, as Australia was generally, that having these general objectives was really not going to be of great assistance, and so there needed to be, at the same time, there was some engagement with the United States to try and bring them back into the fold, I suppose, one way of expressing it. Anyway, though, as history shows, the 6 objectives were basically put and discussed within the conference, and a group of 77 rejected them. Very strong group, a powerful group within the conference, which led the United States to then coming back with more specific proposals for amendment, over 150 in what was called the Green Book, which is also part of the significant history of the 11th session and UNCLOS generally. Well, there was still, though, a great interest on the Australian and, I know, New Zealand part to do what we could to try and encourage the United States to come back into the negotiations, and that required an effort to really look at some of their proposals and to see what adjustments might need to be made, particularly in relation to the deep seabed mining provisions, which were the major concern to the US. So a group was formed, about 12 countries, and it was called the Good Samaritan Group. And that group, Australia, New Zealand, part of that, did what they could to select some of these proposals and look at ways of engaging through delicate diplomacy with the US and with others to try and reach some sort of way forward. Eventually, a paper was prepared by that group, which was put to the United States. And there's an interesting story there about, evidently, it was rejected in Washington, or so the reports came through. But then on the final day of the session, there was an indication that the US could actually support the proposals in that paper. But it was too late in the conference to accommodate and to open everything up again. So that might have been an opportunity lost. And of course, the convention was put for adoption and adopted with the United States and 3 other states voting against. Of course, the story doesn't really end there. We know that there was then the whole question of entry into force through ratifications, and that's something we'll be talking about a little bit later on. But it was 2 very quick other comments. One, in relation to the Australian role, Henry's really outlined that in the sort of points that I was going to make. I was struck very much at that 11th session by as I had been, of course, in Canberra, having been involved in some of the preparations, was the collegiality, the coherence, the fact the Australian delegation, right from the outset, of course, had very clear objectives, but also the flexibility to work within those objectives to secure our interests, and above all, to work with others to achieve a comprehensive convention, a comprehensive convention that was universally supported. That was the primary objective. Of course, we were, as I've mentioned, and has been mentioned by Henry, we were part of a number of different groups, particularly the Coastal States Group, but others, where we tried to pursue and advance our interests. But so the Australian approach was very much a joined-up one, and I would fully endorse and share the points that Henry's made about the delegation and the approach it took. And as a final comment, I'd just say that I mentioned personal development, having been involved as a very junior Foreign Service officer in an exercise like this of enormous complexity. It's the points that really Henry and Bill have already made about strong leadership, the package approach, consensus, working through groups, the secretariat. There were really some very significant individuals involved in UNCLOS III throughout. And one I would particularly mention is Ambassador Tommy Coe. I mean, Bill and Henry saw them in action at different stages. I saw him in action in the 11th session, and the way in which he conducted himself was absolutely outstanding. And I think the fact that we actually had a convention and were able to at least adopt text and keep it together at that point was so much to his skillful chairmanship as president.
Thanks, Richard. That was really rich context about that critical final session. And your personal reflections actually lead really well into what I wanted to ask Penny. Penny, for some of us, and I include myself in this, UNCLOS and the law of the sea are pretty much synonymous. But this wasn't always the case. You studied international law and became an international lawyer in New Zealand during this really exciting period of development and change in law of the sea. And I found myself wondering what that was like, and perhaps what sense you had at that time about the outcome of the negotiations or the opportunities or challenges for New Zealand.
Well, thank you very much, Camille. And also, can I just say it's a great pleasure to be on this panel with Bill and Richard and Henry. So I was studying in New Zealand during the 1970s. And so for me, it was a time of real excitement for somebody with an interest in law of the sea. So attention was very much focused on the opportunities for New Zealand, particularly through the EEZ regime. And the context is that it was estimated that the New Zealand EEZ would be 14 to 15 times larger than the New Zealand landmass. New Zealand also had an exceptionally large continental margin, and the regime of the continental shelf had already given New Zealand jurisdiction over non-living resources on the continental shelf. The Maori natural gas field had been discovered, and after the 1970s oil crisis, there was a real push to exploit the Maori gas field and to undertake further oil and gas exploration. And there was also the prospect of phosphate nodules on the Chatham Rise. The negotiations also provided an opportunity for enhanced jurisdiction over marine pollution. And the particular focus for New Zealand in respect of marine pollution was oil pollution from tankers. And given our very long coastline, an oil spill would have a significant impact on New Zealand. You have to recall that in the 1970s, the Tory Canyon oil spill took place in 1969 and the Amoco Cadiz in 1978. So the EEZ was, however, also seen as having a great economic opportunity in terms of exploitation of fisheries. And in 1977, the Pacific Islands Forums, through the Port Moresby Declaration, decided to establish extended zones of fisheries jurisdiction as soon as possible. New Zealand did so in 1977, which you'll recall was before the conclusion of UNCLOS. And there was a little hesitation at that stage as to whether the New Zealand zone would be accepted by others. So related to this was one of the several challenges relating to the outcome of the negotiations, and I'll identify three. So first, the allocation of domestic surplus, which was linked to the acceptance by others of our zone, enforcement, and also the question of highly migratory species. So first, we have to recall that what became Article 62 of UNCLOS was that the coastal state would determine its capacity to harvest the fisheries resources of the EEZ and allocate the surplus to foreign fishing nations. So foreign fishing countries were at that time fishing within 200 miles of New Zealand, and they were the Soviet Union, South Korea, Taiwan, and Japan. New Zealand adopted the very classical approach of concluding access agreements with Soviet Union, South Korea, and Japan. And these access agreements also ensured that the countries accepted New Zealand's sovereign rights over the EEZ. And so that was an important part of those agreements. But the real challenge was how to increase New Zealand's domestic capacity so that it could benefit from the EEZ resources and to ensure that its fishing industry, which at that time was very small, could grow. So New Zealand adopted the approach of having joint ventures and charter arrangements where foreign flagged vessels were chartered and became part of the New Zealand domestic fleet. So this was supposed to be a transitional measure while New Zealand developed its own capacity to fish the EEZ. However, it became entrenched in New Zealand fisheries for 30 years. And ultimately, this approach posed so many issues that it was phased out. The second challenge that I want to mention was enforcement. New Zealand didn't have a dedicated fisheries enforcement capability, and there'd already been instances of illegal fishing, foreign fishing in New Zealand waters. We did have some naval vessels, but the question was still how to enforce the world's fourth largest EEZ. By way of example and an anecdote, I went to a conference held at the Ministry of Foreign Affairs in 1976, and it comprised officials and members of the fishing industry and others, including me. And during the conference, a man stood up and said, "I am the captain of a naval frigate, and there is no way that I'm going to spend the rest of my life chasing fishing boats." So that was a kind of an indication of the importance of enforcement and the challenge of enforcement, which still exists today. It's no longer an issue of enforcement against foreign vessels so much as an issue of domestic enforcement of New Zealand's regulations. Another significant challenge was over highly migratory species. And some of you will recall that the US took the position in its 1976 Magnuson Act that highly migratory species, specifically tuna, were exempted from the Act, and it sought to ensure that tuna were managed by applicable international fisheries agreements. But the arrest of the very large US purse seiners, the Danica in 1982 and the Jeanette Diana in 1984 by Papua New Guinea and Solomon Islands, respectively, highlighted the very divergent views between the US on the one hand and the Pacific states, including Australia and New Zealand on the other. So that issue has pervaded relations between the Pacific states and the US in the years after 1984. It culminated in the negotiation, the renegotiation, and the further renegotiation of the US tuna treaty between the US and certain Pacific states. I'm going to stop here because that is a whole story in itself. But suffice to say that UNCLOS presented both opportunities and challenges, which continue to this day. Thank you.
Thanks, Penny. That's so true. And it's lovely to unwind follow some of these threads back and see where they started. I have read a wonderful book about the Jeanette Diana, and it really does highlight what was actually happening at the time. I recommend that to anybody else as well. Now, we've been talking about the adoption of the Convention and UNCLOS III, and that, of course, wasn't actually the end of the negotiations about law of the sea issues, and in some senses it was only the beginning, certainly in terms of the implementation of the Convention. So I want to go back to Richard, and ask you about the 1994 agreement. I know Australia was a strong supporter of the Convention, and you've talked about the role that Australia played in the Good Samaritan Group, but ultimately it wasn't satisfied with the provisions in Part 11 of the Convention about mining in the area, and it didn't immediately ratify the Convention. And I wonder if you could talk a little bit about that, and perhaps about Australia's role in the Boat Paper Group that negotiated that first implementing agreement.
Yes, Part 11, as it existed in the draft text, would have been acceptable if it had survived, you might say, without the development in relation to the United States. So when, as I say, when the US put forward its proposals, there was an attempt to accommodate or try and address those in a way which would, in effect, preserve the essence of what was in Part 11. But of course, that did not prove possible, as I've mentioned. So what happened after the convention was adopted? Of course, then there was the focus on ratification and bringing the convention into force itself. And of course, that process continued, you might say, throughout the rest of the 80s and, of course, into the 90s. But of course, it became apparent towards the end of the 1980s that the 60th ratification was imminent, and that the convention would come into force very soon thereafter, in the sense that the convention would cover those states that, of course, who had ratified, but equally it was recognized that there were many states, particularly from the from the developed world, who had not ratified. So this was of some concern, particularly within the United Nations Secretariat, and the Secretary General took the initiative to organize some informal consultations, specifically focused on Part 11, the deep seabed mining regime, to see if there was some way of coming up with a formula that might be attractive and bring on the support of states like the United States, but also some other industrialized countries. So those informal consultations proceeded from 90 to 94, and at the same time, Satyanandan, who had been a Fijian permanent representative in New York, and who then was appointed the Undersecretary General for Law of the Sea in the UN Secretariat, he convened a very small informal group of six representatives, plus I understand 2 others who were called two amigos to the group. And Satya chaired that very informal group that was looking at texts and proposals. And a colleague of mine, who's one of Australia's authorities on law of the sea, Dr. Greg French, he was the unofficial rapporteur, because there was no sort of formal standing for this group, but he was the unofficial rapporteur of the group, and he was tasked with putting together the various proposals that eventually resulted in a resolution and what became the implementing agreement. But the implementing agreement was based essentially on 2 versions of a paper which came out of this group of small group of representatives. The first iteration was in August 1993, and the second one was in November. And evidently, Greg has told me that when that when the group was about to publish their paper on an informal basis as a basis for consultations in August '93, Satyanandan said, "Well, we should have something on the cover of this paper to give it a bit of flavour." So Greg said, "Well, I'm going to put a picture of a boat up there," and he took the photo actually from within his book. He'd published a book some years earlier on deep sea bed mining. So he took this picture of the boat, and then he decided it needed a little bit of, you might say, embellishment. So you'll see on that picture that's on the screen, at the back, there's some choppy water. That's the water that the boat is moved through. And in the front, it's settled water. So the idea was that the paper with its substantive content would take the convention and particularly the deep sea mining provisions into smoother waters. And then, of course, he drew polymetallic nodules on the bottom. Anyway, this was published, and evidently, to complete the story, anecdotally, the French representative, when he saw this paper who was drawing on it, he said, ce papier bateau. And so that became the boat paper. That's the origin of the boat paper. And of course, as you know, the provisions that contained in it were very successful in being adopted as an implementing agreement with a resolution and widely supported in the conference and adopted before the convention came into force. So it was quite a significant development. Again, an example of very effective diplomacy particularly by the late Satyanandan, who was such a considerable figure, and as we all know, went on to become Secretary General of the International Seabed Authority. But again, an exercise of quiet, effective diplomacy, which was a hallmark, as certainly throughout the 11th session, and as others have mentioned, was a feature of the entire UNCLOS III negotiation phase.
Thanks, Richard. Thanks for that wonderful story about the boat. I noticed it says SS 18 November on it. It's a great item to have. Now, of course, as we discussed, Australia chose not to ratify the convention until this accommodation had been reached on Part 11. But this did mean that there was plenty of time to adjust Australia's legislation and bring it into line with the convention, and particularly the new entitlement to maritime zones. So I wondered, Henry, as legal advisor to the Australian government, what the key challenges or steps taken were during that time, or what you might say about how Australia approached that element of the task.
Well, we were slow. We had plenty of time to get our law in order, given we didn't ratify until 1994, just before it came into force internationally. And of course, it had been concluded back in 1982. So there was plenty of time. And we had moved cautiously throughout the negotiation to assert various rights we might have had. So we had established a 200-mile Australian fisheries zone and dealt with some of the same issues that Penny had mentioned that New Zealand had to face, what to do with other fishing nations and so on. But we weren't in any rush. We did extend our territorial sea to 12 nautical miles in 1991. By the time the convention was concluded in 1982, we'd spent quite a few years negotiating with the Australian states about the offshore constitutional settlement and the division of rights and responsibilities between the federal and state governments in the offshore area. And that was basically all finalised and entered into force in 1983. So we'd sorted out that issue. But we weren't quite sure what else we would need to do in order to ratify the convention, leaving aside all the Part 11 negotiations that were going on. And so Bill Ederson, who was at the ANU at that stage, was commissioned to prepare a report for departments that basically went through each article of the convention to work out what legislation or other changes might be necessary in order to enable Australia to say we were compliant with the Law of the Sea Convention. I think it's fair to say that as it was a surprise to many of us, but there was very little in a sense that imposed the sort of obligations that required legislative measures to be taken. There were lots of rights that one could avail oneself of, such as extending one's continental shelf and having an EEZ rather than a fishing zone. But in terms of actual obligations, requirements that you would have to do that were different from those that perhaps we'd had since the 1958 conventions, there weren't that many of them. One area that did require some work was marine pollution, but in 1981 we'd managed to enact quite a major legislative package dealing with the marine pollution. And so even in that area, we found we were in a reasonably good space. And so we didn't find that there was too much that had to be done before one could legislate, before one could ratify, if government was willing or ready to do so. The main change that we did do legislatively before we ratified in 1994 was, of course, to amend the Seas and Submerged Lands Act to enable us, to give us the benefit of the new maritime zones, to enable us to use the new continental shelf definition, to have an EEZ rather than a fishing zone, and to assert rights over the contiguous zone and so on. And so there were major changes made in 1994 leading up to Australia's ratification that enabled us to fully assert the maritime zones that the new convention entitled us to. But the interesting thing, as I said, was that there was not a great deal of legislative work apart from that had to be done in order to enable us to legislate. That didn't mean there weren't some implementation issues that arose, as Penny said. No, the Law of the Sea Convention does throw out numbers of challenges in numbers of areas. One issue that led to some concern was how one dealt with compulsory pilotage in the Torres Strait and reconcile that with the passage through straits provisions. There were issues about the contiguous zone and what enforcement powers we ought to have in the contiguous zone and beyond, not only in relation to fisheries, but in relation to immigration and other issues as well. And so those issues have gradually been dealt with, but more as in an evolutionary sense rather than in any sense of dealing with it all before one ratified a convention. As with some treaties, you in a sense get your legislative package through, then you can ratify the convention. With the Law of the Sea, it's been much more ad hoc, gradual evolution, gradual implementation, gradual recognition that there's an issue here we need to legislate. But I'll stop there.
I suppose that resonates with the idea of a constitution for the oceans. So moving, I suppose, continuing forward in time, we're now sort of in the 1980s, and pressure on the high seas fisheries in that time grew rapidly. And although UNCLOS III had only sort of recently finished, it became apparent soon enough that another international conference would be needed to address the challenges of managing the fish stocks that Penny's spoken about, in particular, moving between the newly extended 200 nautical mile EEZs of different states. So Bill, I wanted to ask you if you could reflect on the challenges in this context from a New Zealand perspective, perhaps building on what Penny said and reflecting on the negotiation of the fish stocks agreement, which of course took place before the convention itself had entered into force.
Thanks, Camille. Well, I should probably begin with a disclaimer. I wasn't directly involved in the negotiation of the fish stocks agreement. By that stage, I was CEO of the Department of Conservation, and that department's only direct interest in the negotiation was limiting the important question of limiting the effects of high seas fishing on albatrosses and petrels, many species of which breed in New Zealand and spend much of their time in the high seas. But let's go back a bit. In theory, UNCLOS could have established a global organisation to manage high seas fisheries. It didn't. Why? Well, because it was successfully argued at the time that different oceans with different stocks and different conditions might need different rules, and therefore management responsibility should rest regionally or sub-regionally. But as you say, Camille, within a decade, the pressure on high seas fisheries was such that it was clear that another effort at the multilateral level was going to be necessary to elaborate the pretty general UNCLOS provisions on straddling stocks and highly migratory stocks. Now, I think I'm right that for its part, New Zealand didn't have a large number of straddling stocks of concern. There might have been a bit of testiness with Australia over in relation to fishing for straddling orange roughy stocks in the Tasman. But I believe our main focus in the lead up to the conference was really the issue of the highly migratory stocks and the vital interest of the Pacific Island states in the development of rules that would enable them or help them really in the management of, and of course the return from, the vast stocks of tuna that migrated through their zones and the adjacent seas. Perhaps I should mention that one highly migratory stock, southern bluefin tuna, was one that was of interest to both Australia and New Zealand, but by that stage that was being managed under a trilateral voluntary agreement with Japan that was later formalised into the 1994 CCSBT treaty. But in the late 80s and early 90s, the most high-profile controversy over straddling stocks was that between Canada and the EU, more particularly Spain and Portugal, over the Grand Banks cod stocks. And clearly this was a significant driver behind the call for a new conference in Agenda 21 of the Rio Conference on the Environment. But there was strong backing for that call from a range of coastal states. There was, I believe, a core group that included Canada, Iceland, Norway, New Zealand, Argentina, and Chile, but expanded with others coming in later. And as I understand it, part of New Zealand's role in both the preparatory work and in the conference itself was to try to ensure that the issue of highly migratory stocks was not overshadowed by the straddling stocks issue. Now, the Pacific Island countries were again actively involved and following a lot of background discussion and lobbying, were very pleased to see Satya Nandan of Fiji elected to chair the negotiations for the new implementing agreement. In terms of the relationship of the new agreement to UNCLOS itself, it's noteworthy, I think, that the call in Agenda 21 and the subsequent UNGA resolution later that year, it heavily emphasised the fact that the work of the conference on these two issues and its results should be fully consistent with the provisions of UNCLOS itself. As to the negotiations, there was a lot of detail on that, which I wasn't involved in, but it clearly highlighted the obvious but still fundamentally important point that a high seas area can't be managed effectively if straddling or highly migratory stocks are overexploited in adjacent EEZs, and similarly, in reverse, a coastal state can't effectively manage a straddling or highly migratory stock while it's inside its zone if it's overexploited on the adjacent high seas. And the result overall was a detailed elaboration really of everything necessary for regional and sub-regional fisheries management organisations to be effective, and all of them cast as formal legal obligations. I'm not going to summarise them, but I think it's worth recalling in particular the primacy that was to be given to scientific advice in decision-making, and in that regard, the elaboration of the famous precautionary approach. From a New Zealand perspective, I think the development of these detailed rules was directly in line with our UNCLOS objectives, in particular our peace and security interests, and also our concern that the Pacific Island nations should be able to benefit from the resources in the seas around them, not just continental land territory. had the negotiation of that new implementing agreement not been undertaken, I think there was a real possibility that the rising fishing pressures would have risked a return of the conflict or threat of conflict that had been a major driver of the UNCLOS negotiations themselves. And I think it's also worth remembering that the negotiation of the new agreement, like the negotiation of UNCLOS, had a significant effect on the development of customary international law. And as you've indicated in the discussion so far, Henry and Richard have covered, and Penny, that we particularly were relying on customary international law when we took what some regarded as a very bold move to put our EEZ in place before the treaty had actually entered into force. That said, the negotiations we had with the distant water fishing countries, I remember I was heading the legal division at that time, and when we put our zone in place, and I would still rate those negotiations with the foreign fishing countries as some of the most interesting, shall we say, that I've had in my career. Thank you.
Thanks, Bill. Oh, to be a fly on the wall at some of these negotiations. Penny, I want to come back to you. The second implementing agreement, as Bill's outlined, addressed some of the gaps in the convention relating to the high seas, but not all of them. And you've been closely engaged over the years now in the negotiations for a third implementing agreement on biodiversity beyond national jurisdiction, which is still on foot. So I wondered if you would like to make any observations, perhaps in that context, and perhaps about how New Zealand's position on law of the sea issues has changed or evolved, or even stayed the same over that period.
Thank you, Camille. Just want to recall that the BBNJ process, that's the negotiations on biodiversity beyond national jurisdiction, first commenced in 2006 through an ad hoc informal working group, which was looking into studying issues relating to the conservation and use of marine biological diversity beyond national jurisdiction. So the New Zealand position on BBNJ has remained fairly consistent since that time. However, like Bill, I have to make a caveat that I was attending the ad hoc informal working group meetings as the head of the New Zealand delegation. And then subsequently, I have been involved in providing advice as the legal advisor to the Western Central Pacific Fisheries Commission, but not directly involved in the negotiations themselves. But I want to answer this question by considering what's changed in New Zealand's approach and position and what's largely remained the same. In terms of what's changed, it seems to me that at the time of the Law of the Sea negotiations, it was thought that UNCLOS would provide the framework for addressing oceans issues into the future. So the emphasis in the early days of the BBNJ discussion was on looking at the mandates and the work of existing organizations and trying to harness them together and to make clearer the rules regarding cooperation and coordination between these various organizations, including RFMOs, regional fisheries management organizations. But the UNCLOS framework has not been able to address some of the complexities relating to areas beyond national jurisdiction. So one example is that in one of the issues in the package that is being discussed in the negotiations is marine genetic resources. So the question is, are the resources of the area beyond national jurisdiction the common heritage of mankind, or should the freedom of high seas, in particular the freedom of marine scientific research, apply? So New Zealand and a number of other states have sought to move the discussion away from a debate on principles and instead focus on the practicalities of a benefit regime for marine genetic resources. The reason for this is that there was a lot of discussion on whether or not the common heritage of mankind applied to marine genetic resources in areas beyond national jurisdiction, and this was clouding the whole discussion. So New Zealand, together with others, including Australia, have tried to move to a more pragmatic approach An example of the maturing of the New Zealand position is its approach to the creation of new institutions. So there's general support in New Zealand for regional fisheries management organisations, RFMOs, and their role in fisheries management. And this is very consistent with New Zealand's traditional support for the UN Fish Stocks Agreement that Bill's mentioned. There was a view, particularly among fisheries officials, that the BB&J issue was more to do with filling gaps in the global coverage of RFMOs and addressing the lack of mandate of some RFMOs to address marine biodiversity in areas beyond national jurisdiction. So this meant that at the beginning of the ad hoc process, there may have been a reluctance to create a new large supranational global institution because of the potential to undermine existing organizations, not only regional organizations, but also the sectoral organizations. However, during the ad hoc process, New Zealand became a very strong proponent of a new internationally legally binding agreement, which sets global standards and strengthens existing regional and sectoral organizations. And that it is definitely now accepted that this may include the need for a global institution. So one noticeable development over the last 40 years has been the increasing importance attached by New Zealand to marine environmental issues. 40 years ago, there was a degree of emphasis on economic opportunities from the law of the sea, tempered by an acknowledgement of the importance of the protection of the marine environment. But now there's increasing attention paid to ecological issues and the need to take an ecosystem approach to the management of marine resources. So rather than a stock by stock or a species by species approach, the need to look at the whole ecosystem as a whole. And that includes not only fisheries, but bycatch, but also more broadly than that. And this is really apparent now in the BB&J negotiations. So a final shift in approach has been a greater appreciation of the importance of traditional knowledge and its role in the conservation and management and conservation and sustainable use of marine biodiversity. And there's greater consideration now being given to Mā, Tauranga, Māori, and other Indigenous traditional knowledge, which will inform our knowledge about BB&J. So in terms of what stayed the same, I would say that New Zealand has followed its UNCLOS negotiating tradition and worked to try to facilitate solutions to problems and to find consensus among divergent positions in the BB&J negotiations. So I recall leading a small working group in the ad hoc working group where we sought to hammer out an approach to establishing a preparatory conference for the BB&J process. And John Adank and Alice Rebel from the New Zealand side were facilitators at one of the discussions, on area-based management tools. So there has been both a high degree of consistency, both in our approach and in our positions, with some nuances and some maturing of position as the negotiation has proceeded. Thank you.
Thanks, Penny. I've really enjoyed all of those reflections, and I do have one more question that I want to ask all our speakers, but I'd also like to preserve a bit of time for questions, and I'd like to invite our participants to send some questions through the Q&A function if they would like to, or else when I invite you to in a moment to put your hand up to ask a question. So I will ask our speakers if they could keep their final reflections very short, perhaps a minute or two in the frame of sort of concluding observations. I would like to ask each of you if you'd like to share a reflection on one area, one aspect of the convention that significantly impacted you in your work as a government legal advisor, or any sense of the actors or interests or issues it raised, or how it might play out in the future, perhaps some unfinished business or an itch you'd like to scratch in the context of UNCLOS. I might go first to you, Penny.
Thank you, Camille. So I'll try to be really quick on this. I have a lot to say on it, as you probably can imagine. So we've already heard today that UNCLOS was envisaged to be the constitution of the oceans and to provide the framework. But over the 40 years, there's been increasing acceptance that there's gaps. And nowadays we're dealing with another type of issue. And this is, I think, going to be the issue of more importance as we move into the future. And this relates to the interaction between UNCLOS and other regimes, such as human rights, climate change, or trade. So in the area of human rights in particular, I'm very interested in labour standards on fishing vessels. And as a government legal advisor, you can't just look at UNCLOS, but you have to look at some of these broader regimes. So in respect of fisheries, we have seen reports, we've all seen reports of human rights abuses on fishing vessels and concern over the working conditions for crew, and especially those that spend a lot of time in international waters. This was a real issue for New Zealand, and it was to do with the foreign chartered vessels that I mentioned, where we had foreign flagged vessels which were considered to be part of the domestic fleet in New Zealand. There was, because of the huge number of abuses that were being reported in the allegations, which was having a reputational issue and impact on New Zealand, there was a ministerial inquiry into this issue. And as a result of the ministerial inquiry, they considered all these different issues, including the UNCLOS regime, the various IMO, ILO conventions, and the various rights and responsibilities of coastal states, flag states, port states, and market states, and came to some conclusions, but the government went beyond the recommendations of the report and decided that in future there would be no further foreign chartered vessels in New Zealand waters that were foreign flagged. So any chartered vessel now has to receive a New Zealand flag, which gets around the jurisdictional issues that the inquiry found. So the point of this is that this was just one example of what's happening in New Zealand, what happened in New Zealand. There's a huge issue out there of labour standards on fishing vessels and the need for a real coordinated approach between the various regimes, not just UNCLOS, but also the labour regimes, the maritime transport regimes, in order to try to address this issue. So I will stop there. Thank you.
Thanks, Penny. I think we'd have a whole other seminar on that. And I'll give a plug for a new article you have coming out in the Melbourne Journal about labour standards on fishing vessels. I might go to Richard, actually, because Richard, I think your mic's on. So let's go to you next.
Okay. Well, perhaps this is a slightly different response to your question, but I'm very personally committed to the rules-based order. And the Law of the Sea Convention, to me, as I said, it had personal impact on me, and it just demonstrated when states get together on the whole, and there's goodwill to create a constitution of the oceans, in that case, then it can be achieved. And of course, I know the United States is not a party, but of course it acts in accordance with the provisions of the convention, and have 168 parties to that convention. So to me, that is the Law of the Sea Convention is let's say, a foundation stone of the rules-based order. And I would really like to see all parties adhere to its provisions, to what they've signed up for. That, to me, is a little bit my frustration, that not all states that have done so are fulfilling their obligations. So that's by way of a comment on the convention. I think it's a very important convention. It's evolved, of course, through these implementing arrangements and agreements, but we should all, as parties, be making sure that we call out states that do not adhere or abide by the provisions of the convention they've signed up to. The other aspect I'd just like to comment from an experience point of view. I mean, there are many facets of the convention that in Department of Foreign Affairs and Trade and in the Attorney General's Department and other agencies in our respective governments who involve aspects of the Law of the Sea Convention. But I think one of the really positive aspects in an Australian and New Zealand sense, if I can say that, is our engagement with our Pacific Island neighbours and states on law of the sea issues and the dialogue that goes on. They're very important, whether it's obviously oceans and climate, very significant for those states as for both of our states. And of course, fisheries, maritime boundaries, and there's been some excellent work that's been done in assisting Pacific Island states to finalise their maritime boundaries, particularly on the Australian side, led by Attorney Generals. So there are some real positives there, I think, in terms of our relationships in the Asia-Pacific region in particular.
Thanks, Richard. I couldn't agree more with both of those points. And it's been actually really interesting to see how the Pacific has come out so often in comments throughout this session. The Pacific sort of seems to be an integral part of the Australian and New Zealand experience and perspective. So it'll be great to explore that further in our next seminar, which is the direct topic of that seminar. I might go to Bill next, if that's okay.
Thanks, Camille. The issue I want to reef on about was can be summed up in the idea that consensus is a good goal, but it's a problematic rule. Now, why do I say that? People forget these days that the first session of the UNCLOS negotiations was 6 weeks in New York devoted to procedural issues and organisational issues and adopting the rules of procedure. Why? Because from the beginning it was recognised that issues all we were dealing with were all closely interrelated, and new rules would have to be developed as a package. You couldn't do it one by one. Traditional voting would be a problem because all states were likely to have some elements of a complicated negotiated package that they weren't too keen on. But if they were able to vote on each element, they'd be likely to record their formal opposition, and that might preclude them feeling comfortable about going in favour of the package as a whole. So that led to the adoption of consensus as the principal means by which decisions were to be taken. And we spent an awful lot of time on that and in developing the rules of procedure so that the conference had to take a formal decision that all efforts at consensus had been completed or exhausted before any voting took place. And that was all backed up with a so-called gentleman's agreement, couldn't do it these days, that was appended to the rules of procedure. But that innovative emphasis on a drive for consensus, I think, has been had a major positive influence on other international negotiations subsequently. It's definitely an effective way of ensuring that states carefully consider whether their dissatisfaction on one issue is so serious that it warrants a formal objection that may affect the agreement or the ability to get an agreement on an overall package that's widely seen as essential. But in some cases, including some RFMOs, consensus has been established as the only method by which decisions are taken. To me, that's a mistake. Its effect is to provide every participant with a veto, and therefore, at the very least, an effective stalling device. In the case of RFMOs, in my view, it's even of doubtful consistency with Article 10J of the Fish Stocks Agreement, which says that the states must develop decision-making procedures which facilitate the adoption of conservation and management measures in a timely and effective manner. Now, certainly all efforts should be made to achieve consensus before a vote is taken, but voting shouldn't be ruled out. We all know the decisions on total allowable catch, for example, or allocations are tough. And instead of one or two members being exposed as voting against a science-based decision that others are prepared to accept, this decision can simply be blocked. And I remember an appalling situation a few years ago where we had in one RFMO, the scientists had advised the stock was down to 4% of its unfished biomass, and the relevant RFMA couldn't get any consensus on any hard decisions necessary to reverse it. In my experience, that includes a number of subsequent organisations, including SPRIFMO, but the possibility of voting affects the negotiating dynamics in a positive way and increases the pressures to achieve consensus. And of course, it's important to remember that in the end, as Richard's outlined for us, after enormous efforts to get consensus, the UNCLOS III conference had to vote, and we wouldn't have the Law of the Sea Convention today if it could only have been adopted by consensus and had the president it did in the form of Tommy Cove. At the same time, I think in an RFMO context, at least it's reasonable to have a safeguard such as an objection procedure to ensure that a majority decision is neither discriminatory nor unlawful, but in turn, that sort of procedure shouldn't be able to be used as a delaying tactic. And I think we got the balance about right in SPRIFMO. More generally, I think the UNCLOS negotiations, there isn't time to go into it, generated a raft of procedural lessons and procedural techniques that have proved very useful in quite different contexts and might well warrant revisiting as memories fade. Thanks.
Thanks, Bill. You certainly played a really important part in that SPRFMO decision-making procedure, and if people haven't had a look at that, it's worth having a read. Henry, you're going to get the last reasonably brief word.
Yes, I'll be brief. I was going to mention dispute settlement, something I've been involved in, that Australia's been involved in with maritime cases like bluefin tuna, the Timor-Leste conciliation, the Volga case, and even whales, even though that arose under the Whaling Convention rather than Law of the Sea. I mean, the dispute settlement provisions in the Law of the Sea Convention are detailed, complex, full of compromises, and clearly not perfect. And when I first started to reflect on them, I began to think, well, look, it's all a mess and really not necessarily a very good system. On the other hand, I'm sure it's true that we wouldn't be able to get the system we have today if we were negotiating today. And having the system, despite its flaws, despite its complexity, despite the fact there's competing forums, whether it's UNCLOS or ad hoc arbitration or conciliation, nevertheless, it exists. There are challenges in the dispute settlement area, competing jurisdictions that Penny has mentioned in terms of legal regimes is one. There's the issues that are present in any international dispute settlement system, with states that don't want to turn up or states that dispute jurisdiction. And my conclusion after reflecting on it was that we are lucky to have at least some system of dispute settlement, despite its flaws. It's better than nothing. No, I don't think we should despair with it. The problems it faces and its imperfections are really faced by international dispute settlement generally. So I see it as a positive part of the Law of the Sea Convention. Thank you.
Thanks very much, Henry. We've got a few minutes, about 10 minutes remaining for some questions. I've got a couple that have been submitted through the chat, the Q&A function, but if anybody would like to put up their hand, turn on their video and ask a question to our panellists, I'm also very happy to facilitate that. I might read out a couple of the questions that we have, and then I'll open it up to the panel to comment on questions they're interested in or would like to answer. One question which seems to resonate with the recent House of Lords inquiry, which I'm not sure if any of you made submissions to, but if you didn't, now is your chance, is, in your opinion, is the Law of the Sea Convention fit for purpose for the 21st century? So I don't know if you've got any particular themes or comments you'd like to mention there. Another of our participants is asking us to look out beyond Australian and New Zealand perspectives and think about the global interests in the conservation of biodiversity. And they're wondering whether we think that's an important part of UNCLOS. I think there's an implication also in the question about the use of the word resources. We keep talking about marine living resources, and are these things more than resources? Should we be talking about biodiversity and conserving biodiversity? And another question around any lessons, and some people of you have already touched on this, but what lessons we might draw from the experience of UNCLOS III in approaching future UN lawmaking exercises. So in the absence of any hands up physically or emoticonally, I might see if any of our panellists want to address those questions. There's 3 there, and I'll perhaps just go around one by one and you can answer any of them that you'd like. Henry, you're still in my screen there. Do you have any things you'd say to any of those questions?
Well, just to pick up on, is it fit for purpose? I mean, there are clearly gaps, as we've seen in implementing agreements. There are clearly issues that will need to be addressed. But it's, as it were, the basic law, the Constitution, and I think for the most part, it is fit for purpose, and it provides a mechanism and process whereby these other issues, the gaps, the uncertainties, the ambiguities can be addressed. I'm not sure that I'd say an amending conference or anything like that is appropriate, but rather one has to work alongside the Law of the Sea Convention in implementing agreements or otherwise to deal with the issues, but it continues, I think, to be fit for purpose. Thanks.
Thank you. That picks up a little bit on what Richard was saying before about if only states would actually implement what they've signed up to. So I might pass across to Richard. Richard, for comments on any of those questions.
Yes, I fully share Henry's comments there. I still think it is fit for purpose. And I think that the fact that there is the opportunity through the United Nations system with the annual meetings on oceans and law of the sea and the informal consultations that are conducted prior to the discussion of the General Assembly resolutions provides an opportunity for all UN member states, in fact, to present their views on where the convention might be perhaps improved in its implementation. But essentially, I hold the view that it's in its entirety, with the implementing agreements, that it really is still fit for purpose. It is so comprehensive. But it does provide, through these other mechanisms, the opportunity for states to focus on developments and aspects that require discussion at the international level to try and perhaps get some form of broad agreement. In relation to the question, lessons from the experience of UNCLOS III, I mean, I think there are a lot. I touched on some of them very briefly, but for example, in large-scale negotiations, I've subsequently been involved in the lessons, as I was trying to indicate briefly, that I learned from UNCLOS III, and particularly that 11th session, and the approach taken proved invaluable. I mean, when I think of the International Criminal Court statute negotiations, the package approach, working through multiple groups, the consensus approach to that, there are some very common elements in the approach that was taken in that conference that relate really to what occurred in UNCLOS III.
Penny, any comments from you on those questions?
Well, thank you. I like others, I think that there are issues with UNCLOS and potential ambiguities. And like Richard, I think I see a real role for the processes, the UN processes. Not so much the meeting of states parties, but in particular the informal consultative process, the ICP, and also the Oceans Resolution. But I think that what can really, UNCLOS and Law of the Sea can benefit from using those more effectively. Those processes exist, but they're not very formalized and they're not used to the same extent as they could be used. And so I think that these are very important, particularly for some of those forward-thinking issues in terms of the interaction between the UNCLOS regime and other regimes. Because it's a UN body, it's really the only one which can deal with some of the mandate issues which other organizations may have. And so I would only encourage states to use those mechanisms more and to try to move things forward by, for example, having greater recourse to sort of soft law instruments which might help to assist in the interpretations of some of the ambiguities of UNCLOS. And I think that would really help in ensuring that it is fit for purpose into the next 50 years or 40 years. I just want to say something also about the conserving biodiversity. This is a big issue, and that is why these negotiations are taking place on BBNJ. There is a real view that marine biodiversity has been lost, and that this is a need to protect marine biodiversity. And the question is, how is this best done? And so that's something very much for the future. And let's hope that the conference going on and the negotiations are successfully concluded. Thank you.
Absolutely, thank you. And made all the more challenging the last couple of years by the different methods of meeting that everybody's had to engage in. And thank you for picking up that conservation question. Bill, did you have any reflections on fitness?
Well, let me say for a start, there's no such thing as a perfect international agreement. Never has been, never will be. And I think I answered that first question by saying, don't muck about with it and try and negotiate. You'll pull it all apart. And you'll only end up with something, a situation that's much worse. But I totally agree that we need to work with it, that we've talked about the implementing agreements. I agree with everything that's been said about working for that sort of area. For example, this going to the point that Penny's just covered, when we were negotiating back in the 70s, the general scientific thinking was that outside the immediate coastal zone, the deep seabed was basically a desert. There was nothing much out there. And so the idea you could talk, the only thing that was out there was manganese nodules, which you were going to pull up from there. I mean, now we think, we find that that's no longer the case, and also that actually engaging in seabed mining might have serious consequences. So I think I'll stop there. Yeah. Except to say again that in terms of procedures, I think there's a lot to be mined out of that. We've got a huge international community. You cannot negotiate with 190 odd countries around. You couldn't do it back in the Law of the Sea days when we were talking a much smaller number. You have to negotiate in small groups, but you have to find creative mechanisms in each context as to how where you get to in a small group can be translated into the wider conference and get broader acceptance. And that will be different in each case, but it needs careful thinking.
Thanks, Bill. I think some really great messages in there. Don't mess with it. It's definitely one that will stick with me. Unfortunately, that's all we've got time for with our panel this evening. So with sincere thanks to Bill, Henry, Penny and Richard for their generosity, and to all of you for joining us, I'm going to hand back to my co-chair, Professor Rothwell, to conclude our webinar.
Thanks so much, Camille. And can I just add my thanks to Camille's acknowledgement of the contributions this evening from our four speakers. Look, this has been a terrific way to kick off this series. As I said in my introductory remarks, we look forward to rolling out with these webinars effectively on a 2-monthly basis. We hope that we'll be able to announce a big highlight in conjunction with the Australian New Zealand Society of International Law annual conference in June, July. And I know that President Karen Scott, President of ANZL, has been working closely to secure a keynote speaker along the themes that we're looking at today for that event in the middle of the year. So thank you all for engaging, and we look forward to seeing you hopefully in 2 months' time. Goodbye and good night.